In our first video about getting a divorce in Vermont, you learned about the first 2 steps, knowing your rights and what's required, as well as talking to your spouse about issues like your children and your property. Find a list of issues to talk about, other videos, and many more details in the Divorce Roadmap on our website at vtlawhelp.org. Now you're ready for the paperwork. Step 3. Complete the forms. Figure out if you will have a stipulated divorce, where you and your spouse agree on important issues about your children and property, or a contested divorce, where you don't agree on one or more of these things. Each kind of divorce requires different forms. If you are the one starting the divorce process, you are called the plaintiff on all forms, and your spouse is called the defendant. Filling out forms can take some time. Be sure to follow the detailed steps in our Divorce Roadmap at vtlawhelp.org. Step 4. File and serve the forms. When you are done with your forms, file them with your local family court. Filing means you send or bring them to the court. You also need to serve or deliver the forms to your spouse in a way that ensures they are received. Follow the instructions in our Divorce Roadmap, depending on your situation. If you can't afford the filing and service fees, you can apply to have the court waive the fees. Step 5. Go to meetings and courses. A Vermont divorce can include a number of steps, such as an interim domestic order, a case manager conference, required courses, mediation, parent coordination, temporary orders, and hearings. Your divorce may include some or all of these things. Our Divorce Roadmap explains each type of hearing or meeting you may have. Be on time for all appointments and meetings. Let the court know if you have an emergency and need to continue or reschedule a hearing or meeting. If you have children, make sure someone can watch them while you go to court appointments. Step 6. Go to the final hearing and get a divorce order. Your divorce will become final after you go to your final hearing in front of a judge. If you and your spouse came to an agreement about your children, money, and property, the judge will ask you some basic questions at the hearing. This is called an uncontested hearing and can be very short. The hearing is just to make sure you both understand the agreement and that it is fair to you and your children. If you and your spouse don't agree on one or more issues, you will have a contested hearing. The judge will decide on any issues you don't agree on. Contact Legal Services Vermont if you know or think you will have a contested hearing. We can give you quick advice and, in some cases, refer you to a lawyer for more help. After your hearing, the judge will issue a final divorce order. Your divorce becomes final 90 days after the judge issues the order. With a stipulated divorce, you may waive the 90 days. Sometimes you may need to file a motion with the court after the hearing. A motion is like a complaint or request. For example, maybe your ex-spouse isn't following the visitation schedule for your kids or paying the mortgage bill they agreed to pay. Or you might want to change the child support, custody, or visitation decisions in your divorce order. If you can't work it out with your spouse, you may need to file a motion. If you need help, contact your local family court or Legal Services Vermont.